In this module, we'll explore some of the legal aspects of content moderation, and in particular, how various laws, both in the United States and elsewhere, have been used to censor or moderate content on the internet. Let's get into some of the overviews of the laws that are relevant to this discussion, and in particular, how some of these laws have been used to censor speech. One of the central questions that we look at when we look at the question of content moderation on the internet, and in particular the moderation of online speech, is to what extent an internet service provider, content provider, or platform is responsible for the speech that exists or is engaged in on its platform or on its network. In addition to some of the conventional laws, we'll also look at some economic practices that can introduce friction into the access of online content. In particular, the practice of so-called zero rating, which provides internet users some content for free while charging them for other content. In this context, we'll explore the extent to which the cost of internet access or the cost of internet data might act as a financial nudge towards certain types of content. Censorship and the law are very much entangled and entwined. Laws are often the basis for whether content is published, stays online, is removed, and so forth. And the control of online speech can take various flavors, including copyright, online content moderation, network neutrality violations in the form of blocking, throttling, or prioritization, or even the prevention of so-called public participation, such as commenting in online reviews or online forums. We'll talk about the legal considerations first, and in subsequent modules we'll talk about the technical enforcement of some of these laws, including the technical enforcement of copyright. And then we'll turn to some more subtle effects, including how net neutrality interacts with censorship, as well as how some of these financial instruments, such as zero rating, can also act as tools for information control and censorship. Let's start by talking about the legal aspects of content moderation. We'll begin our discussion with the Communications Decency Act. The Communications Decency Act was passed in 1996. The overall law was intended to protect minors online, and most of the law itself was ruled unconstitutional. But there was a particular section of the law, in particular Section 230, which was upheld in the courts. This particular section of the law protects internet service providers and content platforms from being liable for the words of others that use their platforms. This remains law today, although it has certainly been subject to challenge and potential threats of revision. The relevant case pertaining to Section 230 is Reno versus ACLU in 1997, where the Supreme Court answered the question of what laws apply to online content. This was the first Supreme Court ruling on the regulation of materials applied to the internet. And the ruling was that the Communications Decency Act was overbroad, but it did preserve certain restrictions on obscenity and child pornography. However, the ruling guaranteed significant First Amendment protections for online communications, treating online communications that take place on internet service providers and on content platforms much more like print media than like conventional broadcast media. Section 230 remained relatively unchanged for about 2 decades. But just a few years ago, we saw some recent amendments through the FOSTA and SESTA legislation that was passed in 2018. This federal legislation amended Section 230 so that certain other types of activities, in particular sex trafficking, does not provide the content providers immunity or safe harbor. It also makes it explicitly illegal for websites to profit from sex trafficking. There was a particular site, Backpage.com, that was the target for much of this particular legislation. Some free speech groups criticized the amendments as a so-called internet censorship bill, pointing out that creating specific carve-outs for types of content where the content providers are no longer immune creates a slippery slope where other types of content might also be subject to a lack of immunity in the future. This, of course, has some implications for automated detection, enforcement, and takedown. Because if a content provider or internet service provider becomes liable for this or any type of content that's posted or hosted on its platform, then it's incumbent on the platform to take action to remove that offending content. An important nuance, of course, is whether the platform is liable regardless of whether it's been notified about the content. If it so happens that the platform is liable even without notification of the offending content, that implies that platforms would need to deploy some kind of large-scale automated mechanism to detect, enforce, and take down the offending content. In summary, platforms and ISPs generally enjoy safe harbor protection and are not liable for content and speech of their users, thanks to Section 230 of the Communications Decency Act. Recently, laws have clarified and amended certain cases and application domains, such as sex trafficking. Mandates concerning intermediary liability have implications for censorship and speech, and because implementing them at scale may require the deployment of automated technologies, some of which may be very expensive, the implementation of these laws may also favor incumbent platforms that have the resources to deploy content moderation technologies and strategies. Let's now take a look at the Digital Millennium Copyright Act. The Digital Millennium Copyright Act came into law in 1998. This law made the production and dissemination of technology, devices, and services that circumvent access control on copyrighted works illegal. The key point is that ISPs and content providers have limited liability for copyright infringement by their users if they take certain actions. This is so-called Title II Safe Harbor. The limitations on liability are as follows. The ISP or the content provider can be held not liable for copyright infringement if it acts in accordance with takedown notices. Failure to abide or act on these takedown notices can have severe consequences. In late 2019, for example, the internet service provider Cox Communication was charged with a $1 billion fine for failure to take appropriate action on more than 10,000 takedown notices on copyrighted works that were allegedly being exchanged on its network. On the other hand, the DMCA has also been used to silence critics. As we know, for example, it's nearly impossible to do things like review a book or a movie or a game without using text or images from that copyrighted work. Copyright has a carve-out called fair use that allows for such excerpts to be taken in various contexts, including review, literary critique, and education. And yet there are many examples where people have attempted to use the DMCA and other copyrighted laws in an attempt to silence critics. Most recently, this even happened in the field of computer science academia, where a particular author complained about the nature of a review that she received, posted the critique on social media, and subsequently received threatening requests to take down the posting on the basis of copyright infringement of the review itself. Now, in terms of copyright laws and censorship, intermediary liability does vary by country. And in some countries, outdated laws blur the distinction between the content distributor and the intermediary and the regular internet user, making the regulatory jurisdiction between these parties unclear. There's another legal hammer that's sometimes used to silence critics, called a strategic lawsuit against public participation. In these cases, plaintiffs file complaints or cease and desist notifications to critics in an attempt to silence them. Here's an example of a SLAPP lawsuit notification that I personally received in response to a review that I posted on Google. As you can see, I received a threat letter that asked me to take down the review with the threat of seeking damages of $250,000 if I did not. Now, typically, a plaintiff doesn't intend to win these cases, but the goal is to get the defendant to cede on the basis of fear, the threat of legal fees, or simply exhaustion. And often it works. For this reason, so-called anti-SLAPP is an active area of legislation. Many states have anti-SLAPP laws, but some of these laws have been struck down as unconstitutional. Some countries also have some form of an anti-SLAPP law, including British Columbia in Canada. In summary, the law is often used to implement censorship through a variety of tactics. Sometimes the speech itself is made illegal directly, but more often than not, the levers can be indirect, using the law as a tool for fear, intimidation, financial threats through legal costs, and so forth. And laws in seemingly unrelated areas, like copyright, can also be used as a tool for censorship.